All right, wonderful people. Gray Fox back again, reading the Redemption Manual, continuing, leaving off with emergency rule summary. Current law permanently codified in United States Code 95A and 95B, October 6, 1917, Woodrow Wilson submits to Congress and passes the Trading with the Enemy Act, an act to define, regulate, and punish trading with the enemy, and for other purposes. Congress, with this act, defined who was to be considered the enemy, and this act gave the government total authority over these individuals to do with as it saw fit. This act, Section 2, Subdivision C, in the middle, and again at the bottom of the page, other than citizens of the United States, Section 5B, other than credits to be executed wholly within the United States. Note, FDR, Federal, Franklin Delano Roosevelt served on Wilson's staff. March 3rd, 1933, President Hoover receives proposed executive order from the Federal Reserve Board. Whereas the nation's banking institutions are being subjected to heavy withdrawals of currency for its hoarding, and whereas these conditions have created a national emergency, whereas it is provided in Section 5B of the Act of October 6, 1917, as amended, that the President may investigate, regulate, or prohibit under such rules and regulations as he may prescribe, by means of licenses or otherwise, any transactions in foreign exchange, and the export, hoarding, melting, or earmarking of gold and silver coin or bullion or currency. And March 4th, 1933, Franklin Delano Roosevelt's inaugural address asks for war powers. I am prepared under my constitutional duty to recommend the measures that a stricken nation in the midst of a stricken world may require. I shall ask the Congress for the one remaining instrument to meet the crisis, broad executive power to wage a war against the emergency, as great as the power that would be given to me if we were in fact invaded by a foreign foe. March 6, 1933, FDR issues Proclamation 2039, whereas is provided in Section 5B of the Act of October 6, 1917, as amended, that the President may investigate, regulate, or prohibit under such rules and regulations has, typo here, as he may prescribe, by means of licenses or otherwise, any transaction in foreign exchange, and the licenses or otherwise, any transactions in foreign exchange, and the export, hoarding, melting, or earmarking of gold or silver, coin, or bullion, or currency. And now, therefore, I, Franklin Delano Roosevelt, or Franklin D. Roosevelt, do hereby proclaim, order, direct, and declare that from Monday, the 6th day of March, to Thursday, the 9th day of March, 1933, a bank holiday, and that during said period, all banking transactions will be suspended. See Banking Holiday, Black's Law Dictionary, 4th edition. March 9, 1933, the President receives pre-approved war powers and ownership of gold is made illegal. 93rd Congress, Session 1, Chapter 1. The actions, regulations, rules, licenses, orders, and proclamations herefore and hereafter taken, promulgated, made, or issued by the President of the United States or Secretary of the Treasury since March 4th, 1933, pursuant to the authority conferred by Subdivision B of Section 5 of the Act of October 6, 1917, as amended, are hereby approved and confirmed. 48 Statute 1. Okay. Section 3, Section 11, Act of October 6, 1913, as amended, are hereby approved and confirmed. 48 Statute 1. Section 3, Section 11 of the Federal Reserve Act is amended and amended by adding at the end thereof the following subsection N. Whenever in the judgment of the Secretary of the Treasury such action is necessary to protect the currency system of the United States, the Secretary of the Treasury, in his discretion, may require any and all individuals, partnerships, associations, and corporations to pay and deliver to the Treasury of the United States any and all gold coin, gold bullion, and gold certificates owned by such individuals, partnerships, associations, and corporations. All right. All right, kind of got lost there for a second. March 9th, 1933, Senate document number 43, 73rd Congress. First session states the ownership of all property is in the state. Individual so-called ownership is only by virtue of government, i.e., law amounting to mere user and use must be in accordance with law and subordinate to the necessities of the state. 1935 to 36, Supreme Court rules following cases as unconstitutional. 1935, or May 6, 1935, Railroad Retirement Board versus Alton Railroad Company. 295 U.S. 330, May 25th, 1935, ALA, Chester's, was it? Skechers Poultry Corp. versus United States, 295 U.S. 495, January 6, 1995, United States versus Butler, 296 U.S. 1, May 18th, 1936, Carter versus Carter Coal Company, 298 U.S. 238, Moorhead versus New York EX, Red, Tipaldo, Tipaldo, 298 U.S. 587. So 1937 to 1938, after cries that FDR was trying to stack the court, resignation and death allowed Roosevelt to appoint enough justices of his political belief to reverse their previous decisions, and peacetime constitutional barriers to the socialist wartime agenda were removed. The original understanding doctrine was replaced with the doctrine that the Constitution was an evolutionary document. July 24th, 1973, a special committee on the termination of the national emergency, Senate Report 93-849, since March 9th, 1933, the United States has been in a state of declared national emergency. These proclamations give force to 470 provisions of federal law. These hundreds of statutes delegate to the President extraordinary powers ordinarily exercised by Congress, which affect the lives of American citizens in a host of all-encompassing manners. This vast range of powers taken together confer enough authority to rule this country without reference to normal constitutional process. September 14th, 1976, Public Law 94-412 of the 94th Congress, to terminate certain authorities with respect to national emergencies still in effect, and to provide for orderly implementation and termination of future national emergencies. The provision of this act shall not apply to the following provisions of law: the powers and authorities conferred hereto and actions taken thereunder. First Section 5B of the Act of October 6, 1917, as amended, 12 United States Code 95A, 50 United States Code APP, I'm not certain what that is, Appendix, I guess, 5B, we'll go with that. Conclusion: Americans are governed by the statutes codified at Title 12 United States Code 95A and 95B, which originated from the Act of March 9th, 1933, and the Act of October 6, 1917, as amended, giving the Executive Board war powers over the people. I tell you what, I don't think it should sound like that. It doesn't sound like proper English. I'm going to repeat this. Conclusion. Americans are governed by the statute codified and at Title 12 United States Code 95A and 95B, which originated from the Act of March 9th, 1933, and the Act of October 6, 1917, as amended, giving the executive broad war powers over the people. Just consider, okay? Continuing on, instruments signed for accommodation, UCC 3-419. A. If an instrument is issued for value given for the benefit of a party to the instrument, accommodated party, and another party to the instrument, accommodation party, signs the instrument for the purpose of incurring liability on the instrument without being a direct beneficiary to the value or of the value given for the instrument is signed by the accommodation party for accommodation. B. An accommodation party may sign the instrument as maker, drawer, acceptor, or endorser, and subject to subsection D, is obliged to pay the instrument in the capacity in which the accommodation party signs. The obligation of an accommodation party may be enforced notwithstanding any statute of frauds and whether or not the accommodation party receives consideration for the accommodation. C. A person signing an instrument is presumed to be an accommodation party, and there is notice that the instrument is signed for accommodation if the signature is an anomalous, there we go, anomalous endorsement, or is accompanied by words indicating that the signer is acting as surety or guarantor with respect to the obligation of another party to the instrument, except as provided in Section 3-605, the obligation of an accommodation party to pay the instrument is not affected by the fact that the person enforcing the obligation had noticed when the instrument was taken by that person that the accommodation party signed the instrument for accommodation. D. If the signature of a party to an instrument is accompanied by words indicating ambiguously that the party is guaranteeing collection rather than payment of the obligation of another party to the instrument, the signer is obliged to pay the amount due on the instrument to a person entitled to enforce the instrument only if 1. Execution of judgment against the other party has been returned unsatisfied. 2. The other party is insolvent or is in an insolvency proceeding. 3. The other party cannot be served with process, or 4. It is otherwise apparent that payment cannot be obtained from the other party. E. An accommodation party pays the instrument is entitled. Let me repeat. E. An accommodation party who pays the instrument is entitled to reimbursement from the accommodated party and is entitled to enforce the instrument against the accommodated party. An accommodated party who pays the instrument has no right of recourse against and is not entitled to contribution from the accommodation party. Alrighty, so there are only two types of jurisdiction. Okay, so this is the private versus public, and I kind of got lost here. There are only two types of jurisdiction in this entire universe: that which is private jurisdiction and that which is public jurisdiction. Everything inside your body is private because only you exist there, and it is a very sanitary environment. Everything outside of you is the public jurisdiction and is full of filth. It is like when the scriptures say sweat and blood. Well, that is both jurisdictions. Sweat is public because it shows how much work has been executed to your cells, and blood is internal and is a fluid operation that gives life. All rights come from the right to privacy in the public, as for most people involved in the good fight and of faith. Ooh. All rights come from the right to privacy in the public, as for most people involved in the good fight of faith have come to a great understanding of public court. Don't ask the devil to cast out the demons. For those of you who haven't realized that court is a waste of your time, keep going. And I pray that you will realize the futile effort of raising your constitutional rights and lefts. The public has no final remedy because you are relying on other people to fix your problems under execution of law and to provide the remedy. Something must die. You are the biggest problem to yourself. You have to get your thinking straight in your head before you ever find a remedy that will last. Only you can provide your remedy. Don't ask the public to save you from themselves. Remedy can only be found in a private jurisdiction, that means in a sanitary environment, being your skull. The public jurisdiction is full of instant gratification and lascivious filth. It is the saying, you can't fix others until you fix yourself. Well, you are the solution to all of your problems. Your private existence is where you internally get to make a judgment call. It is by your internal operation that makes it private, not by your virtue of the paper. There is no dividing line between public and private. Okay. It is all on how you mentally perceive things and by their operation as to what side they fall on. Just because you say it is private doesn't make it that way. And it is how you do it or operate it that makes it that way, and vice versa. When things enter the public, they seem to get spun way out of control, probably with the downward spiral of the public. To say it is private doesn't necessarily mean the information is restricted for negative purposes. Probably only that to release the information into the public would corrupt it because the people can't responsibly cope with the newness of liberties that comes with private understanding. There is a veil over their hearts. That is why the Lord spoke in parables. It is because only those that are supposed to understand at that time will. Moses from Mount Sinai first brought down the higher law, private side, and when he saw the people living such terrible lives, worshiping the golden Cafr, C-A-F-R, calf, he knew it would have been a liability on his head if he were to disseminate the higher law to the public masses. So he went back up to the mount and returned with the Messianic law, public side, because that was all the people could handle. Too much constrained liberties can wreak havoc on a people. The private side in its concept is that with the newness of information which increases liberties, that wise decision making is done as to not take away the liberties of others. The golden rule is do unto others as you would have them do unto you, is really what sums up the private thought. The private side requires by its operation and discernment of consciousness or consciences. There we go. All right. Well, since that was kind of ugly, let me repeat that. The private side requires by its operations to discernment of conscience. There we go. All right. If you owe anybody any money, you are public. The private owes no money to anybody, and they are the source of the money. This means that when you act in commerce and accidentally make an offer, you have to provide a check or money order for money to get the other party a remedy. The accepting party must be able to pass through this way. A check is a three-party instrument. You are telling A to pay B. This is a pass-through account because they have to use your name as the drawer of the funds to provide the money to be moved from A to B, and this cannot happen unless you are in the middle. That is why when a person won't accept and provide a remedy, they lose their exemption without you because you cannot pass through their account to get their exemption, and When they don't let you pass through their account to get paid, they lose their exemption until they settle with you. This means you get a letter either demanding something from you, a public acceptance which provides no remedy, or an acceptance letter of you action, of your action, a request or an acceptance for value, both of which are trying to use your name to get their remedy. When it is accepted, the claim made against you was returned to pay for itself. I hope that makes sense. Because we live in a private policy, you cannot be obligated to pay. The most that we can do is accept the paper as though it had value and turn it back on itself, because that is the extent of the obligation that public policy allows. When you accept an offer, the offerer must also allow it to pass through his account by his acceptance of your acceptance. When he has done this, he has technically accepted a bill drawn against you and returned it to you for negotiation. Now that both parties have accepted what has happened, neither party owe each other anything, because the original acceptor returned the claim for full settlement and the offerer accepted the return. Or excuse me, I repent, so sorry. The offerer accepted the return. The debt has been effectively redeemed. When a person continues to dishonor, he is not allowing his exemption to pay for the request, and they don't settle with you. They become public. It is all based around public policy. Bottom line is, we cannot be obligated to pay a debt. The most we can be obligated to do is write up to payment, which means acceptance and return. You have to do all you can, i.e. acceptance and return, and then after that, mercy comes in being grace, because it is your exemption that makes the payment. It is your ability or inability to pay that pays for it. Let's think about that. You have to do all you can, i.e. acceptance and return. And then after that, mercy comes in being grace, because it is your exemption that makes the payment. It is your inability to pay that pays for it. Okay. The only way to sum up everything that is outside your body is to call it the industrial society. It is a public works commerce, both fiscal and calendar years, proprietors, corporations, trust banks, car dealers, manufacturers, the courts, mutual funds, your friends, nightclubs, and the like. It is all the industrial society. Okay. Let's see what this segment is. The money order for gold. The democracy on April 5th, 1933, issued an executive order removing the gold from circulation as a currency. This executive order served the same function as a money order to the United States people for the purchase of all gold in society. Gold is substance and was used in the payment of debt. When the president wrote the money order for all of the gold to be taken out of the system and placed with the government then removed the people's ability to pay a debt because they didn't have any money to pay with. The golden rule is usually summed up in he who has the gold makes the rules. Well, sounds mosaic to me. Mosaic, not Masonic, mosaic. Here is another part of the golden rule they don't tell you about. He who has the gold pays the bills. They got the money, they make the payments. The government then became indebted to the people to pay all of the debts because the government was holding all of the money. You ever heard of the phrase, all money is loaned into existence? Well, that is right, because they are borrowing it from me. The money order debited the people by removing the gold from their possession, which in turn credited the United States government with all of the newly held gold in their possession. This exchange is halfway completed because the gold was taken from the people and nothing had yet been returned. The people now need something in this exchange to balance out the ledger and recredit their original holdings. To complete the exchange, the United States government debited themselves with a promissory note, the promise of Abraham, which in return recredited the people. This was the executing order from the president, killing the legal capacity of the government to control the people. The government was then dead. Debt. Phonetically, it sounds similar. Here is another interesting part. The debtor always has the money because he is the one borrowing it. So when the president wrote the money order which took the gold, they became the borrower, debtor, and that is why there is a public debt. It is because they are borrowing the money from us, the owner. What must happen now is the debt must be redeemed back to the original owner. Here is the executive order, money order, that killed the government and made them the ones liable for every debt they associate to. When you see executive, think execute. And when you see order, think money order. Because all of the money was taken away in an executive order, money order, the president is holding all of the money that can pay the bills. Here is an example. A national emergency occurs and an executive order is issued and money can now be sent to the victims. Another example is when Mexico got money from the United States, U.S., the Congress said no, but then the president by executive order then sent the money. True? Wow. Another example is when the prisons are running out of money and executive order can be issued and now the prisons get all the funding they need. Executive Order of April 5th, 1933. Under Executive Order of President, issue April 5th, 1933, all persons are required to deliver on or before May 1st, 1933, all gold coin, gold bullion, and gold certificates now owned by them to a Federal Reserve Bank, branch, or agency, or to any member of the Federal Reserve System. Executive Order forbidding the hoarding of gold coin, gold bullion, and gold certificates. By virtue of the authority vested in me by Section 5B of the Act of October 6, 1917, as amended by Section 2 of the Act of March 9, 1933, entitled An Act to Provide Relief in the Existing Emergency in Banking and for Other Purposes, in which a mandatory act Congress declared that a serious emergency crisis, I, Franklin D. Roosevelt, President of the United States of America, do declare that said national emergency still continues to exist, and pursuant to said section, do hereby prohibit the hoarding of gold coin, gold bullion, and gold certificates within the continental United States by individuals, partnerships, associations, and corporations, and hereby prescribe the following regulations for carrying out the purposes of this order. Section 1. For the purposes of this regulation, the terms hoarding means the withdrawal and withholding of gold coins, gold bullion, or gold certificate from the recognized and customary channels of trade. The term person means any individual, partnership, association, or corporation. Section 2. All persons are hereby required to deliver on or before May 1st, 1933 to a Federal Reserve Bank or branch or agency therefore, or to any member bank of the Federal Reserve System, all gold coins, gold bullion, gold certificates now owned by them or coming into their ownership or on or before April 23rd, 1933, except the following. A. Such amount of gold as may be required for legitimate and customary use in industry, professions, or art within a reasonable time, excluding gold prior to refining and stocks of gold in reasonable amounts for the usual true requirements of owners mining and refining such gold. B. Gold coins and gold certificates in an amount not exceeding in the aggregate $100 belonging to any one person, and gold coin having a recognized special value to collectors or rare and unusual coins. C. Gold coin and bullion earmarked or held in trust for recognized foreign government or foreign central bank or the bank for international settlements. D. Gold coin and bullion license for other proper transactions not involving hoarding, including gold coin and bullion imported for re-export or held pending action on application for export licenses. Section 3. Until otherwise ordered by any other person becoming the owner of any gold coin, gold bullion, or gold certificates after April 23, 1933, shall within 3 days after receipt thereof deliver the same in the manner prescribed in Section 2, unless such gold coin, gold bullion, or gold certificates are held for any of the purposes specified in paragraphs A, B, or C of Section 2, or unless such gold coin or gold bullion is held for purposes specified in paragraph D of Section 2, and the person holding it is, with respect to such gold coin or bullion, a licensee or applicant for license pending action thereon. Section 4. Upon receipt of gold coin, gold bullion, or gold certificate delivered to it in accordance with Section 2 or 3, the Federal Reserve Bank or member bank will pay thereof an equivalent amount of any form of coin or currency coined or issued under the laws of the United States. Section 5. Member banks shall deliver all gold coin, gold bullion, and gold certificates owned or received by them other than as exempted under the provisions of Section 2 to the Federal Reserve Banks of their respective districts and receive credit or payment thereof. Section 6. The Secretary of the Treasury, out of the sum, make available to the President by Section 301 of the Act of March 9, 1933, will in all proper cases pay the reasonable cost of transportation of gold coins, gold bullion, gold certificates delivered to a member bank or Federal Reserve Bank in accordance with Section 2, 3, or 5 hereof, including the cost of insurance, protection, and such other incidental costs as may be necessary upon production of satisfactory evidence of such costs. Voucher forms for this purpose may be produced from Federal Reserve Banks. Section 7. In cases where the delivery of gold coin, gold bullion, or gold certificates by the owners thereof within the time set for the above will involve extraordinary hardship or difficulty, the Secretary of the Treasury may, in his discretion, extend the time within which such delivery must be made. Applications for such extensions must be made in writing under oath under the Secretary of the Treasury and filed with a Federal Reserve Bank. Each application must state the date to which the extension is desired, the amount and location of the gold coin, gold bullion, and gold certificates in respect of which such application is made, and the fact showing extension to be necessary to avoid extraordinary hardship or difficulty. Section 8. The Secretary of the Treasury is hereby authorized and empowered to issue such further regulations as he may deem necessary to carry out the purposes of this order, and to issue licenses thereunder through each offices or agencies as he may designate, including licenses permitting the Federal Reserve Banks and member banks of the Federal Reserve System in return for an equivalent amount of other coin, currency, or credit to deliver, earmark, or hold in trust gold coin and bullion to or for persons showing the need for the same or for any of the purposes specified in paragraphs A, C, and D of Section 2 of these regulations. Section 9. Whoever willfully violates Section 9. Whoever willfully violates any provisions of this executive order or of these regulations or of any rule, regulation, or license issued thereunder may be fined not more than $10,000, or if a natural person may be imprisoned for not more than 10 years, or both, any officer, director, or agency of any corporation who knowingly participates in any such violation may be punished by a like fine, imprisoned, or both. This order and these regulations may be modified or revoked at any time. Franklin D. Roosevelt, The White House, April 5th, 1933. Further information, consult your local bank. Gold certificates may be identified by words gold certificates. Appearing thereon, the serial number and the Treasury seal on the face of a gold certificate are printed in yellow. Be careful not to confuse gold certificates with other issues which are redeemable in gold, but which are not gold certificates. Federal Reserve notes and United States notes are redeemable in gold, but are not gold certificates and are not required to be surrendered. Special attention is directed to the exceptions allowed under Section 2 of the Executive Order. Criminal penalties for violations of Executive Order. All right, I don't know why it went from that to this, but this is where we are. The promissory note to pay our debts. HJR 192 of June 5th, 1933 is the promissory note, the promise of Abraham, the government issued to balance the exchange to credit the people. The promissory note is on the debit side of the United States government ledger. Let me repeat that. The promissory note is on the debit side of the United States government ledger, which was debited from their credited, which was debited from their credit, created by the Executive Order of April 5th, 1933, when they took the gold out of circulation. Public policy is rooted in HJR 182 and is grace that creates our exemption. This is your temporal saving grace. Under grace, the law falls away to create a more perfect contract. Public policy removed the people's liability to make all payments by making a contract null if it required the payment to be in substance, because the people didn't have any money to pay with. All that must be done now to discharge a liability. Okay, let me read that one more time. Public policy removed the people's liability to make all payments by making a contract null if it required the payment to be in substance, because the people didn't have any money to pay with. All that must be done now is to discharge the liability. Pay and discharge, all similar words, but the principles are as different as Old and New Testaments. The word pay is equated with gold and silver, or something of substance like the firstborn lamb, which requires tangible work to be invested in it to remove the liability, because an execution must occur. The word discharge is equated with paper, or even more basic simple credits and debits that exist on paper only, like the slate held by the agents. Like the slate held by the agents, angels of heaven that get swiped clean. Nice. Okay. You cannot pay a bill with a bill, and you cannot pay a debt with a debt. What HJR 92 did was remove the liability of an obligor, someone obligated to pay a debt, by making it against public policy to pay debts. All that needs to be done now is discharge the debit with an appropriate credit dollar for dollar. Debt must be discharged dollar for dollar in the same sense as sin was discharged on the cross. The moment a debt exists, it must be written off. The catch is we can't write off the debt because we are not in possession of the account in deficit. Okay, since I slipped up, let me try that again. The catch is we can't write off the debt because we are not in possession of the account in deficit. Our fiduciary agent is in possession of the account, so we must provide him with the tax return by the return of the original offer, so the fiduciary can discharge a liability through their internal revenue service, the bookkeeper. Most feel that when the money was taken out of society, the people became the slaves. This is not true. The people were freed from every obligation that society could create, thus freeing the people from any obligation which they may incur, simply because we cannot pay a debt. Ask yourself the question, what are you charging me with? And how do you expect me to pay? Simply said, there is no money. Plain and simple for me to take the payment with, and on top of that, if I were to pay, who is paying me to pay that guy, and who's paying that guy, and so on. Public policy is the supersedious bond because it limits our liability to pay. It is the more perfect contract because it operates on grace to pay our debts after we have done all that we can. We can go as far as we can to fulfill the obligation, except and tax return. And after we have done all we can, mercy and grace kick in being our exemption to make the payment. Grace creates our exemption in the industrial society so long as we accept the charge. Public Policy, H.J.R. 192. House Joint Resolution to suspend the gold standard and abrogate the gold clause, June 5th, 1933. H.J.R. Resolution 192, 73rd Congress, first session. Now, I recall, and I'm going to take a break here just to kind of emphasize this. I also recall, I think it's United States Code 31, was it 5118 is also another declaration of the dissolution of the gold standard. Continuing, joint resolution to assume uniform value to the coins and currencies of the United States. Whereas the holding of or dealing in gold affect the public government interest and therefore subject to proper regulation and restriction. And whereas the existing emergency has disclosed that provisions of obligations which purport to give the obligee a right to require payment in gold or a particular kind of coin or currency of the United States, the corporation, or Federal Reserve System, or in an amount of money of the United States, the corporation measured thereby obstruct the power of the Congress to regulate the value of money of the United States, the corporation, and are inconsistent with the declared policy of the Congress to maintain at all times the equal power of every dollar coined or issued by the United States in the markets and in the payment of debts. Now, therefore, be it resolved by the Senate and House of Representatives of the United States of America in Congress assembled that A. Every provision contained or made with respect to any obligation which purports to give the obligee a right to require payment in gold or a particular kind of coin or currency or in an amount in money of the United States, the corporation measured thereby is declared to be against public policy, the public officials' servants, and no such provisions shall be contained in or made with respect to any obligation hereafter incurred. Every obligation heretofore or hereafter incurred, whether or not any such provision is contained therein or made with respect hereto, shall be discharged upon payment dollar for dollar in any such coin or currency which at the time of payment is legal tender for public and private debts. Any such provision contained in any law authorizing obligations to be issued by or under authority of the United States is hereby repealed, but the repeal of any such provision shall not invalidate any other provisions or authority contained in such law. B. As used in this resolution, the term obligation means an obligation including every obligation of and to the United States, the corporation, accepting currency, Federal Reserve notes, and circulating notes of Federal Reserve banks and National Banking Association. Section 2. The last sentence of paragraph 1 of subsection B of section 43 of the Act entitled An Act to relieve the existing national economic emergency by increasing agricultural purchasing power to raise revenue for extraordinary expenses incurred by reason of such emergency, to provide emergency relief with respect to agricultural indebtedness, to provide for the orderly liquidation of joint stock land banks, and for other purposes. Approved May 12, 1933, is amended to read as follows. All coins and currencies of the United States, the corporation, including Federal Reserve notes and circulating notes of Federal Reserve banks and national banking associations, heretofore or hereafter coined or issued, shall be legal tender for all debts for public and private public charges, taxes, duties, and dues, except that gold coins, when below the standard weight and limit of tolerance provided by law for the single piece, shall be legal tender only at valuation in proportion to their actual weight. Approved June 5th, 1933, 4:30 p.m. Prepaid. Prepaid is very simple. The entire economy is prepaid. Look at it this way. We have a car sitting on a dealer's lot. You walk up to buy a car or buy the car. Does the dealer ever tell you, I am glad you are going to buy this car because we have to find out how we're going to pay for this car to be built? No, is the answer you would get. But that is exactly why they are doing, or excuse me, that is exactly what they are doing when they go to the bank to get a loan. When do they ever build something and then talk about how they're going to finance it to be built? The product was paid for when the contract was put in place to collect the industrial resources through the Army Corps of Engineers, EPA, which I think is the Environmental Protection Agency, DOT, the Department of Transportation, and OSHA, OSHA, was it Occupational Health and Hazard Association in Flint, Michigan, to build it. Even more precisely, the item was paid for when the census did a per capita poll to identify how much money those agencies should put into the economy based on our productivity. Unfortunately, take a quick look at Marxism and Keynesianism. Yeah. Edward Bernays Key? No, Edward Bernays. What was it? Key. I can't remember. Well, anyway, economics. What is it? Unfortunately, take a quick look at Marxism and Keynesianism economics to make a connection with your worth and your previous status. Now, everyone with a head per capita, raise your hand. Good. They loaned against you to finance the operation that is the principal account, making the item prepaid for the acceptor. This is another reason why you are the principal. The principal reason you are prepaid is because Christ's acceptance of the sins of in the Garden of Gethsemane and his death on the cross created the prepayment of all your liabilities, both temporal and spiritual, because they are inseparable. Because I wasn't there 2,000 years ago, but my sins were prepaid on the condition that I accept the Redeemer. All right, praise God. You are the source of economic production, being the principal, and your interest accruing from you, i.e., a per capita census statistics, was pledged as the collateral to be the sponsor of the monetary system's credit. I feel so good about that. I'm going to repeat it. The principal reason you are prepaid is because Christ's acceptance of the sins in the Garden of Gethsemane and his death on the cross created the prepayment of all your liabilities, both temporal and spiritual, because they are inseparable. Because I wasn't here 2,000 years ago, but my sins were prepaid on the condition that I accept the Redeemer, apparently Jesus. You are the source of economic production, being the principal, and your interest accruing from you, i.e., a per capita census statistics, was pledged as the collateral to be the sponsor of the monetary system's credit. That is why when interest that accrues from the principal gets returned, tax return, to the principal, there is a decrease in tax liability, a deduction. Okay, so the deduction is the deduction or the decrease in the tax liability. Nice. I like to say that with such emphasis. That sounds like good news to me. The vendor is paying his taxes to you. That is why it is a tax matter. Tax is just a return of the interest to the principal. Courts. Busted. All right. General instructions. Disclaimer. Any information passed along via email, paper copies, or computer diskettes is for educational purposes only and does not constitute legal, professional, or tax advice. It is the reader's responsibility to study the issues, laws, and decide what to do with this information. All of this information pertains to taxes rules, and these rules may differ in your state, county. Some of this information is simply personal preference and personal opinion. So please study the issues and make up your own mind about everything you choose to do. Number 1, answer immediately. Do not put off paperwork. Number 2, never answer a third party, but respond with a rejection of contract offer, telling him and all of his heirs, agents, and assigns that they are third parties and to get out of your commercial affairs. Number 3, always send the rejected offers of contract back to the entity that sent them to you, and then copy anyone else involved. I.e., if you get a summons complaint taped to your front door and it doesn't say where it came from, it probably came from the sheriff. Reject it and send it back to the sheriff's via certified or registered mail. Then copy the court, then send a copy to the court and other party to the summons, usually a lawyer. If you get it in the mail, make sure you look at the return address, because sometimes a service company sends it to you. It must be rejected and sent back to the service company, and then all other parties copied on it. 4, always remember they are after subject matter jurisdiction. Number 5, the only thing involved in any controversy or court case is about jurisdiction. Number 2, subject matter jurisdiction, or SMJ, is the same as challenging the court's jurisdiction, but in a nicer way. Instead of telling the judge that the court doesn't have jurisdiction, you are telling the court they don't have jurisdiction over the subject matter to hear the case. This gives them an out. Subject matter jurisdiction is over the living person, and that is why they never have it. They must have first-hand knowledge and be a party to your contract, but they never do or are. Don't argue the charge, the amount, or anything other than subject matter jurisdiction, because when you start to argue the issues, you grant subject matter jurisdiction. Number 7, subject matter jurisdiction can only be gained with your permission by consent. By consent. Or assessment. Making a plea grants consent. A, everything they do against us in court is by affidavit, and usually without any notice to us. You must check the court file daily to see if anyone has placed an affidavit against you, and you must rebut every affidavit with an affidavit. We will be lawful, though, and give grace and notice with our affidavits. So if you rebut an affidavit or generate an affidavit, always send it to the person it is against. Copy the court clerk if it is involving a court case, giving personal notice and a grace period to rebut it. You must include an address for them to send a rebuttal to. You must include an address for them to send a rebuttal to. Either your address or a notary address. I suspect that the notary is who is supposed to receive the rebuttal. Number 9. What we are finding out is that even though we do an affidavit into court challenging subject matter jurisdiction, that unless you go in at the appointed court time and stand up for the affidavit, the judge will put a default judgment against you. We've had added a case we have added a cease and desist order to the affidavits, which may take care of having to go into court, but this hasn't been established yet. I will not use the zip code, as it is for federal jurisdictions only, creates jurisdiction, and sets up a pattern that you are a federal citizen. Sample address is as follows: Jackrabbit Patriot, non-domestic, CO, care of, /O, 123 Lakewood or Lakeview Drive, Dallas, Texas. Number 10, also only use a stamp because that doesn't create jurisdictional problem, but their stamp machines may. Number 10, I got to repeat that. That's interesting as heck. Also, Only use a stamp because that doesn't grant a jurisdictional problem or create a jurisdictional problem. But there's stamp machines made. See, that's good. Good to know. 11. You can take jurisdiction of all letters you send. Return receipt request cards, envelopes, etc. by signing your autograph in red ink at the bottom right on both the front and the back sides of the pages, cards, envelopes, etc. And make sure you write it where no one else can sneak a number or mark past it to the right or underneath your autograph. Number 12. With the autograph is used instead of signature under the living man's name because a signature is only the signature of someone's name authority. It is not their real name. Do you ever hear anyone chasing a movie star or famous sports hero saying, "Hey, give me your signature"? No, it's always, "Can I have your autograph?" Number 13. When the copy claim is used because anything you copyright, copy claim, is protected from being used against you in a court of law unless you introduce it as evidence. Please read through these documents carefully to ensure that all names, addresses, or other information has been inserted correctly and to ensure that you know what you are sending out. You are responsible for your documents, no one else. Number 14. In the negative of virement, list your town and any town of anyone who is coming against you. For instance, if a judge in another town is sending you a summons, then list his town and state too. 15. In the negative of virement, the lines provided are for the following statements to be handwritten in red ink. I am not a fictional limited entity. I am a natural-born child of the Creator, Yahweh. Capital letters here, YHWH, Yahweh. I am not a surety or accommodation party for any fictitious person. I choose to be the Creator. I choose to use the Creator's Hebrew name that he instructs Moses to tell the Israelites because I believe it carries the weight of truth. Obviously, this will be a personal religious conviction. Any and all of this information can be changed to suit your particular beliefs situations. This is your information, not mine, so change it as you see fit. Just include that you are not a fictional limited liability entity, otherwise known as a corporation. Number 17. The UCC forms require Adobe Acrobat Reader to work. Adobe Acrobat Reader can be downloaded from the internet for free. Always use the international form. Current revision is 7. Oh, okay.